When we talk about constitutional rights, we sometimes talk about them in silos.
You've got your First Amendment people over here, your Second Amendment people over there, your civil procedure nerds over there.
Yeah, they all stay in their own lanes.
But every once in a while, a case comes along that just crashes two of these worlds together and creates a legal black hole.
That is exactly what we tackle today in United States versus Hemani. The Supreme Court hears oral arguments in this case on March 2nd.
We have the Second Amendment specifically, the right to own a gun for self-defense, joining forces with the First Amendment, colliding head-on with federal drug laws. It is a messy, messy intersection.
And not just any drug laws. We're talking about the awkward, half legal, half illegal reality.
Marijuana.
Mm-hmm.
Because let's be honest, the map of the U.S. looks like a patchwork quilt right now. You have states where you can walk into a store that looks like an Apple store and buy cannabis, and then you have federal law that says absolutely not.
Right? So you can be following state law perfectly.
Mm-hmm.
Buying from a licensed dispensary, paying your taxes, using it for sleep or recreation. But the second you also own a firearm, you're a federal felon.
Yeah, and this isn't just about one guy in Texas. This is the case that's challenging the entire federal ban on so-called unlawful users owning guns. Keywords, unlawful users.
This is the same law that prosecutors convicted Hunter Biden over in 2024 based on Hunter's firearm application that asked if Hunter was an unlawful drug user.
So let's set the stage. A person owns a handgun for home defense, totally legal. He smokes marijuana a couple times a week, legal in his state. Fine. But together?
Federal crime, up to 15 years in prison.
That seems completely insane. Unlike owning guns and smoking cannabis apparently, subscribing to podcasts remains completely legal in all 50 states. Please follow, rate, subscribe, and share the podcast on Apple, Spotify, YouTube, anywhere you listen to podcasts. And follow us on LinkedIn to get written updates. Questions about this case? Reach out to us via LinkedIn at the High Court Report or email at scotus.cases.pod@gmail.com.
All right, here's what you need to know. In this case, the Supreme Court must answer whether 18 U.S.C. Section 922G3 violates the Second Amendment as applied to Respondent.
That tells us absolutely nothing.
Let me translate. Section 922G3 makes it illegal for anyone who remains an unlawful user of or addicted to any controlled substance to possess a firearm.
Define unlawful user.
That's the million-dollar question. The statute doesn't say habitual user or addicted person. It just says user. So if you smoke weed twice a month, do you qualify? What about if you smoked 6 months ago? Notice how it mentions nothing of use with a firearm? It focuses solely on your status.
And controlled substance?
Marijuana remains federally illegal even in states where it's legal. So every marijuana user technically violates federal law. So the question becomes, can the government prosecute someone for exercising their Second Amendment right to own a gun if they occasionally use marijuana?
Right. And this gets into the Supreme Court's new framework from the Bruen decision. The government must prove that history and tradition support disarming marijuana users.
What kind of history?
The government points to founding-era laws that restricted habitual drunkards. The question becomes, do colonial-era alcohol laws justify modern marijuana prosecutions?
What does Hemani say?
He argues no historical law ever stripped sober people of gun rights because of what they consumed during their free time.
Let me paint you the picture. Ali Hemani lives in Texas. Clean record, no criminal history. He owns a Glock 19 for home defense and admits to smoking marijuana a few times per week. Both activities legal in many states.
But not together under federal law. On August 3, 2022, law enforcement searches his home and finds the gun. They don't claim he looked intoxicated. They don't charge him with any drug trafficking. 6 months later, February 8, 2023, they indict him for possessing a firearm while being a marijuana user.
Then what happens?
Hemani's lawyer files a motion to dismiss, arguing the law violates the Second Amendment after the Supreme Court's Bruen decision.
Bruen changed everything for gun cases.
Exactly. The magistrate judge agrees and recommends dismissing the case, but here's where the timeline gets chaotic. While Hemani's case sits pending, the Fifth Circuit decides United States versus Daniels, another marijuana user with a gun case.
Same issue?
Identical. Daniels smokes weed 14 days per month, owns a gun, gets prosecuted. The Fifth Circuit says the prosecution violates the Second Amendment.
So the government looks at Hemani's case and basically says, we can't distinguish this from Daniels. They file what's called an unopposed motion for summary affirmance.
The government concedes.
They basically say, we disagree with Daniels, but these facts are identical. If Daniels wins, Hemani wins too. We'll appeal both. District Court dismisses the case on February 1st, 2024. Government appeals. But plot twist, the Supreme Court decides United States versus Rahimi while the appeal sits pending.
What does Rahimi do?
Rahimi upholds a different gun law, Section 922 G8, which disarms people under domestic violence restraining orders. The court vacates Daniels and tells the Fifth Circuit to reconsider.
And then?
The Fifth Circuit doubles down. They decide United States versus Connolly, apply Rahimi's framework, and again, find marijuana prosecutions unconstitutional.
Government files the same concession motion in Hemani's case. Fifth Circuit grants summary affirmance on January 31st, 2025.
Now it's at the Supreme Court. The Supreme Court granted cert because this threatens a massive federal enforcement tool. Thousands of these prosecutions happen every year. Plus, the government argues circuit courts split on how to handle these cases.
Though Hemani disputes that split actually exists, we'll get into that. Bottom line, this case affects millions of Americans and a huge chunk of federal gun prosecutions.
Let's break down what each side argues. The government goes first with 3 main points. The government's main argument revolves around habitual drunkards. They claim founding-era laws restricted the rights of people who regularly consumed alcohol.
What kind of restrictions?
3 categories. First, vagrancy laws that classified common drunkards as vagrants, subject to imprisonment or workhouse confinement.
Does that actually relate to guns?
That's exactly what Hemani asks. The government cites no founding-era law that actually disarmed vagrants. They just note that habitual drunkards could lose business licenses or get placed under guardianship.
Second, civil commitment laws allowing courts to commit habitual drunkards to asylums or place them under guardianship.
Again, not really about guns.
Right? And third, surety laws that sometimes extended to common drunkards, basically requiring people to post bond for good behavior. The government argues these show a historical tradition of restricting drunkards' rights, so restricting marijuana users makes sense.
Hemani fires back, none of these laws actually disarmed anyone, and more importantly, they all required individualized court proceedings.
What does that mean?
Someone had to go to court and prove this specific person presented a danger. Section 922 G3 just says, if you use marijuana, no guns, no individual hearing, no specific findings. The government claims circuit courts are handling these cases differently, creating a 3-way circuit split. They point to the Seventh Circuit case United States versus U.S.C, which upheld the law using older constitutional standards.
But here's the problem with that argument.
U.S.C happened in 2010, 12 years before Bruen changed the entire framework for gun cases.
So the Seventh Circuit never actually applied the Bruen standard?
Correct. The government also cites 2 Eighth Circuit cases, Cooper and Baxter, but those courts just sent the cases back to trial courts without deciding anything. Hemani argues no real circuit split exists. Only the Fifth Circuit has actually decided whether this law passes the Bruen test for marijuana cases.
Here's where the government gets creative. They point to 18 U.S.C. Section 925C, which lets people apply for relief from federal firearms disabilities. Basically, if you think this law treats you unfairly, fill out paperwork and ask for an exemption.
Except there's a hole in this argument. The government admits this relief program remained effectively disabled from 1992 until 2025.
So for 33 years, this relief option didn't exist.
Right? And Hemani got charged in February 2023, 2 years before the program came back. Hemani argues this makes no sense. You can't cure a constitutional violation by pointing to relief programs that didn't exist when the violation occurred.
Hemani flips these arguments. On historical analogues, he argues the government's examples fail both the why and how tests from Rahimi.
Explain those tests.
Why means historical laws must address a similar problem. How means they must impose similar restrictions. Hemani argues founding-era alcohol laws only restricted actively intoxicated people, not regular drinkers during sober periods. The Fifth Circuit in Connolly found, just as there exists no historical justification for disarming citizens of sound mind, there exists no historical justification for disarming a sober citizen not presently under an impairing influence.
What about intoxication laws?
Here's the critical distinction. Historical laws banned carrying weapons while drunk. Section 922, G3, bans all possession by anyone who uses marijuana, even while completely sober.
Hemani argues that difference matters hugely. Historical laws targeted the specific danger of intoxicated people with weapons. This law targets the general category of marijuana users, regardless of their current state. On the circuit split, Hemani says it doesn't exist because only the Fifth Circuit has actually ruled under the correct Bruen framework.
And on the relief process, he argues it's irrelevant because it wasn't available when he got charged, and because administrative relief can't cure constitutional violations anyway.
Time for what this actually means. If the government wins, this affects millions of Americans immediately.
How many exactly?
About 52.5 million Americans, 19% of the population, have used marijuana. About 32% own firearms. Even accounting for overlap, we're talking about millions of people. In 38 states plus D.C., adults can legally use marijuana medically or recreationally, but federal law still criminalizes it.
So you could follow every state law perfectly and still face 15 years in federal prison.
Right? And prosecutors have complete discretion about who to charge. That creates what lawyers call a chilling effect.
Meaning people stop exercising constitutional rights because they fear prosecution.
Exactly. Gun owners might avoid legal marijuana even in legal states, or marijuana users might give up their guns.
What if Hemani wins?
Congress would need to rewrite the law more narrowly, maybe target people who are actually intoxicated while possessing guns, or people with drug trafficking convictions. But here's the bigger picture. This case tests how far the Supreme Court's new Second Amendment framework extends.
The Bruen decision requires historical justification for all gun restrictions.
Right? If the court says colonial alcohol laws can't justify modern marijuana prosecutions, that could affect lots of other gun restrictions.
What about people charged under this law right now?
Thousands of pending cases would get dismissed. Anyone convicted solely for marijuana use plus gun possession could appeal.
But remember, this only applies to the marijuana user provision. People addicted to hard drugs or trafficking illegal substances could still face prosecution under other parts of the law.
The broader question becomes, can Congress criminalize the combination of two otherwise legal activities?
That's exactly what's at stake here.
Bottom line time. Why does this case matter?
Because it defines whether Congress can strip constitutional rights from people who engage in conduct legal under state law. Hemani admits to two things: owning a gun for self-defense and smoking marijuana occasionally, both legal in many states.
But the combination triggers a federal crime carrying 15 years in prison. The Supreme Court must decide whether founding-era alcohol laws justify this modern prosecution. If they say no, millions of Americans get clarity about their rights. If they say yes, Congress gets broad power to restrict gun ownership based on other legal activities. This case perfectly captures the tension between federal and state law and between public safety and individual rights.
Plus, it's the second case this term about how the court will apply Bruen to gun restrictions. The first case, Woolford versus Lopez, was heard in January. We covered that case extensively. If you're interested in learning more about Bruen or the Second Amendment, check out our episodes on Woolford.
Huge stakes for both gun rights and federalism.
That's United States versus Hemani. We'll definitely follow this one closely. Oral arguments should be fascinating, and we'll have a full breakdown afterwards.
If you made it this far, share this episode with someone who thinks Supreme Court cases don't affect their daily life.
Because millions of Americans might be federal criminals without knowing it.
You can find us on Apple Podcasts, Spotify, YouTube. Questions? Hit us up on LinkedIn. Just search the High Court Report. Talk to you soon.